If the 2024 election was the correction for 2020, maybe the Daniel Penny Jordan Neely case was the correction for Derek Chauvin George Floyd, not just for the outcome in court, but for what it represents as a matter of public opinion. One case prompted the Black Lives Matter insanity, and the other might be the end of it, at least for the moment. Back then, burning down entire city blocks and police precincts mostly peacefully was practically a national holiday. Outside of the courthouse today, though, hardly anybody even claps for the screeching hatred of this country anymore.
These wonderful white people, I hope they celebrate their Christmas while the Neely family is praying and asking God for comfort. Goddamn them and goddamn America.
But even if the moment is over in our politics, it certainly is not for the guy who's still locked up to appease that mob, and at least for now will be for most of the rest of his life, if not all of it. Yes, Derek Chauvin is Squidward looking longingly out the window at Daniel SpongeBob Penny and Kyle Patrick Rittenhouse celebrating their acquittals happily in a way that Chauvin will probably never know. Now, of course, these cases aren't exactly the same. Rittenhouse was pure self-defense, Penny was defense of others, and Chauvin's was a lawful arrest with some complicating variables. But Chauvin's George Floyd encounter still had similar elements, a necessary use of force and a creative drug cocktail to make things unpredictable. "Hey, officer, could you please subdue that methed-out linebacker very gently?" was always a rough assignment, but things have only been rougher for Chauvin since. He was stabbed 22 times with an improvised knife by an FBI informant, former Mexican mafia member in prison last year. That guy said he did it on Black Friday as a gesture of solidarity with Black Lives Matter, which I guess kinda makes sense. After all, what is a Black Lives Matter protest if not a very enthusiastic doorbuster sale at 100% off? Sounds like that Mexican stabber got everything but Chauvin's scalp, which of course was already sliced clean off by the mob, and that's probably exactly how Chauvin will remain, as the scalp that the politics of the moment demanded. Not a prisoner as a matter of justice, but at least he's not quitting. Chauvin has made multiple appeals, and one just earned a small win. Exactly what killed George Floyd and exactly why his heart failed will now be re-examined. Recall, Derek Chauvin faced two different sets of charges. First, in Minnesota, a second-degree murder charge on which he was convicted at trial in April 2021, and then federally, a charge of violating George Floyd's civil rights, to which Chauvin pleaded guilty later in December of that year. As a result of the federal conviction, Derek Chauvin was sentenced to 21 years in prison. He was already sentenced to 22 and a half in Minnesota, and he's now serving both sentences concurrently at the Stabby Federal Prison in Tucson. Chauvin is pursuing this appeal in federal court, but the substance of the appeal is actually about the state murder trial. Chauvin made a request to reevaluate George Floyd's autopsy materials in light of a medical expert's opinion about what caused George Floyd's death, an opinion that wasn't specifically considered at trial and which Chauvin says his own lawyer actually withheld from him. Chauvin's lawyer said in a court filing on Friday that re-examining George Floyd's autopsy materials could substantiate the theory of forensic pathologist Dr. William Schatzel that George Floyd's death was unrelated to Chauvin's restraint. According to this theory, George Floyd died of a catecholamine crisis triggered by a paraganglioma George Floyd was already known to have had in his pelvic region. This is a rare type of tumor that can release excessive adrenaline, and that adrenaline rush, in this pathologist's opinion, caused Takotsubo myocarditis, an acute heart failure. In more plain terms, George Floyd had a known condition that could have amped up his heart to potentially fatal levels, plus meth, plus fentanyl. This pathologist's opinion is that George Floyd was literally scared to death. The initial police encounter startled him, his turbo adrenaline tumor started to act up, and that triggered his heart failure. I can't personally speak to the physiology of it, but I do have eyes and I do have ears, and George Floyd certainly looked and sounded irrationally afraid upon initial confrontation, way before Derek Chauvin's guillotine knee was ever a factor.
Step out and face away.
Okay, please don't shoot me. Please, man.
I'm not going to shoot you. Step out and face away.
I'm going to get out of eye, man. Please don't shoot me, man.
I'm not shooting you, man.
Please, man.
But Chauvin's appeal isn't strictly about what happened medically here. It's actually about his lawyer not making him aware of this theory, thus preventing its use in his defense. Chauvin has a new legal team now, and he says his prior defense attorney, Eric Nelson, failed to inform him of this crucial medical opinion, despite this Dr. Schatzel contacting Nelson to explain it in April 2021. Because this information was not given to Chauvin, he says this was ineffective assistance of counsel, bad lawyering, in other words, thus the basis for his appeal. Partly new facts, partly the process by which those facts were considered, or not. And if that sounds overly technical or kooky, well, apparently not too much, because the judge won't dismiss it outright and sees some value and plausibility to the claim. In a ruling Monday, District Court Judge Paul Magnuson in Minnesota, the same judge who oversaw Chauvin's federal guilty plea, granted Chauvin's request for these new tests. The tests include examination of substances preserved from Floyd's autopsy, including blood, urine, and, crucially, heart tissue. Examination will look for elevated levels of those stress hormones and potential signs of stress-induced heart failure. Even though this is a federal appeal, it is potentially relevant in both of Chauvin's convictions. His murder trial was in state court, but ineffective assistance of counsel is a constitutional claim against the process of that trial and would still apply in potentially undoing it, however unlikely that may be. According to Supreme Court precedent, for Derek Chauvin to succeed on this claim, he has to show that his trial lawyer's conduct fell below an objective standard of reasonableness, and a reasonable probability that were it not for his lawyer's unprofessional errors, the trial outcome would have been different. And that standard presents serious obstacles, of course. First, even if this specific medical theory wasn't presented at trial, the claim that medical factors other than Derek Chauvin's knee were responsible for George Floyd's death was, and the jury rejected that theory.
How did the heart and drugs contribute to the cause of death?
They were significant, or they contributed to Mr. Floyd having a sudden cardiac arrest. And speaking and making noise is very good evidence that the airway was not closed.
Would one more alternative medical theory have changed the verdict? Well, even if this one is more credible, I think this was a jury that was already decided regardless, especially considering the public pressure to convict, and that one of the jurors lied his way on for the purpose of convicting, each itself a substantial separate question about fair process. Another complication is the timing. Chauvin's court filing says his former lawyer was contacted by this new pathologist with the new theory in April 2021, but that's while the trial was ongoing. At that point, his defense was already built and active in the courtroom. Is it really unreasonable for his defense attorney to prioritize the existing case instead of chasing down a new theory in the middle of the trial that's substantially similar to the case he's already making anyway? There's a pretty good argument otherwise that it would be unreasonable for his lawyer to get distracted from the task at hand. But Chauvin does have a little more substance there. That contact with the doctor was still prior to Chauvin's federal indictment, and the information his lawyer did not give him probably would have been a relevant consideration in his decision to plead guilty to the federal charges. And then there's the question of what happens even if Chauvin is successful. Let's say this new examination gives serious credibility to this new theory of George Floyd's death, or even proves it outright. Then what? Chauvin has both state and federal convictions to deal with. If he had ineffective counsel in Minnesota, does that mean acquittal on the murder charge? Likely not. It likely means new trial, as far as I understand, and that's not necessarily a double jeopardy issue, because the problem with the original trial in this context was not the fault of the state or prosecutors. But let's say there is a new trial in Minnesota, and Chauvin is acquitted under new facts. What does that mean for his federal conviction? Potentially nothing. The federal charges didn't depend on state conviction, or even the same facts or elements of the crime to prove necessarily. Chauvin pleaded guilty to violating George Floyd's civil rights, and I assume the position of the federal government would still be he did that regardless of whether he murdered George Floyd or not. The federal case did not rely on murder. It relied on the use of unreasonable force and ignoring medical needs. Plus, as part of that same process, Chauvin pleaded guilty to the same civil rights violation charge in a different case. against a 14-year-old boy in 2017. There are many hooks to get off of, in other words, but hey, maybe he is Peter Pan the hook defeater, and if ever there was a time for such improbability, it would be now, because for as trendy as the racial outrage was back then, unlikely political comebacks are so much hotter today. Plus, so is presidential clemency. Joe Biden is setting records for pardons and commutations, so maybe there's room to play by the new rules. Think of that possibility. Chauvin succeeds in undoing his Minnesota conviction, and President Donald Trump pardons him or commutes his federal sentence. And I know it's not going to happen, and I'm not predicting that it will. It would be an incredibly bold move for the president without a lot to gain politically. So I won't expect it, but I won't be content either, because we're not fully there yet. Once I see Derek Chauvin out patrolling the mean streets in studded knee pads, stopping fraudulent banana purchases in their overdose-shaking tracks again, only then will I finally know that we are actually so back. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on X, that is at ML Christiansen. You're always welcome to coming out and chatting my live streams. Those live on Wednesday and Sunday nights. Looking forward to it. Goodbye.